Cooper and Crabtree owned adjoining blocks of land. Cooper had a cottage on his land, occupied by a tenant paying rent. In the UK, they have this rather odd concept called a prescriptive right to light. If a landowner enjoys uninterrupted access to light for 20 years, they can claim a prescriptive right, which would prevent their neighbours, for instance, from building a structure that might block out the light. The prescriptive right could be defeated by blocking out the light for a full year. Crabtree was worried that Cooper would obtain a prescriptive right to light, which would prevent Crabtree from building on his land. Crabtree tried to negotiate, suggesting that Cooper could pay him a small sum annually to maintain the light until Crabtree wanted to build. Cooper refused. Crabtree then built a large hoarding on the boundary between the properties, blocking out the sunlight to the cottage. If Crabtree could maintain that for a full year, then the prescriptive right to light would be extinguished. Cooper went to court arguing that the poles for the hoarding were on his land and therefore were a trespass. Of course, the true purpose was to have the hoarding removed so that the prescriptive right to light was not lost. Cooper lost comprehensively. Master of the Rolls Jessel said of the cottage that it is a new window and Crabtree's right to obstruct it is plain enough. He wishes to obstruct it for a legitimate purpose because the land is building land and he is afraid that the plaintiff will acquire a right of light which may prevent his building on this land. However, if the poles really were on Cooper's land, this was not a trespass against Cooper, but against his tenant who was in possession of the land. The tenant was not a party to the action. The Master of the Rolls said, "The plaintiff is not in a position to maintain an action for trespass because he has a tenant in occupation of the cottage." The hoarding did no damage to Cooper's underlying interest in the land because the poles could be removed at any time, having done no harm at all. From this case, we confirm that trespass protects possession, not ownership. In Australia, the issue of the light itself would be decided in each state and local government area by its individual planning laws.